Okay, hi everyone. We are on chapter 10 on homicide. Of course, I'm going to upload this PowerPoint, but I'm just going to go over some of the slides. We're going to first start off talking about murder. And I want to tell you, you guys did a great job on the first discussion question dealing with the different types of homicide and why we have different categories. So thank you for that. Murder can be either in the first degree or the second degree. First degree murder typically includes malice aforethought. That's just a fancy way of saying implied malice, which means that the person may not have had the intent to kill, but they engaged in activity that was so dangerous to human life. They showed such disregard for human life. They were so reckless that they should have known that their actions would lead to a death. So it doesn't mean necessarily that they intended to kill. But first degree murder can include not only malice aforethought, premeditation, and deliberation. The primary elements are that the offender had the intent to kill, understands what could result from the action, and plans in advance how to do it. That's when you'll usually see first degree murder. Malice aforethought, again, signifies the mental state of a person who voluntarily, without legal excuse or justification, does an act that ordinarily will cause death or serious injury to another. So again, a person that just engages in activity that just is so reckless that they just show a conscious disregard for human life. An example of that could be some teenagers decide we're going to pick up some concrete blocks, stand over the overpass and throw it over the freeway at oncoming cars. They may not, when they decide to do that, they may not have the intention of killing people who are driving in those cars, but their actions are so dangerous to human life that they should have known that death could result. So they could face second degree murder if someone dies as a result. So that's just an example. Premeditation, a lot of times people think that this means that the person, planned a murder for weeks, and sometimes that is the case. But premeditation can be shown, just depending on the facts and circumstances, it can be shown that the person acted within a moment. They decided to kill a person. Like, for example, two people are arguing and it gets really, really heated. And the next thing you know, one person turns to go to their car and gets a knife out of their car and walks back in and stabs the person. Well, the prosecution will use that entire time period. Maybe it only took 1.5 minutes for that person to go outside and get the weapon. But during that 1.5 minutes, they had a choice. And the prosecution would argue that person, while they turned to go to their car, they still had a choice of not to kill. While they walked to their car to get their weapon, they still had a choice not to kill. While they opened the door and they got the knife out, they still had a choice not to kill. While they closed the door back and walked back in, they still had a choice not to kill, but yet they still walked in and they used the knife and they killed the person. That alone can be premeditation. So it doesn't have to be a long, drawn-out plan. Okay, the next slide. In a murder case, the use of a deadly weapon is evidence of the user's intent. That usually makes the case for the prosecution much easier when a person uses a deadly weapon like a gun or a knife. But sometimes people may have a defense saying, I just wanted to scare the person. I just shot the gun into the air, hoping just to scare them, and the bullet just happened to hit the person. But that's typically not very successful. Transferred intent just basically means that even if you say, I didn't intend to kill Ralph, I intended to kill John, but Ralph stepped in the middle of he stepped in the line of John, you can still, that's not a defense. The fact is that you were trying to kill someone, so your intent to kill Ralph transfers to your killing of John. And also, there are jurisdictions that say if you happen to kill the wrong person, but you also kill your intended victim, you're going to be charged with 2 murders. So you can read more about that in the textbook. Now, second degree murder is can be caused, shown, for example, the example I gave you with the teenagers throwing the concrete over the freeway. But it just remember it in this way, that it's when someone has acted so reckless and in such disregard of the high risk of death that they acted with a depraved heart and with an extreme indifference to the value of human life. That is when you will see second degree murder charged as opposed to first degree. Another circumstance where you would see second degree murder charged in California is what's known as the Watson murder. So in California, we now have a law that if you are found to be driving drunk and you kill a person, you could face a second degree murder charge. Now, most DUIs where someone has caused someone's death, most of them are charged as vehicular manslaughter cases. But there are those special cases where the prosecution feels they can convince a jury to convict someone of second degree murder. You usually find that in cases where the person has had multiple DUIs. They've been given the Watson acknowledgement, which basically anytime you're convicted of a DUI, the judge has to tell you, you need to know that in the future, if you get another DUI and you kill someone, you can face murder charges. So when the prosecution can show that the defendant has been given that advisement, they have at least 2 other DUIs, multiple DUIs. They had a very high blood alcohol level, and their driving was extremely dangerous. They were speeding. They were driving recklessly. They ran a red light. If those facts and circumstances are involved in the case, then you will see a prosecutor charge a person with second degree murder based on driving drunk. So that's known as the Watson murder exception in California. We talked about felony murder in some of the previous chapters, but again, if a person dies during the course of a felony, a particular type of felony like a robbery, a home invasion, and the person dies during the course of a different but related felony being committed, that person who committed the felony that resulted in the death will be charged with the murder, even in the absence of the intent to kill. So if you are a felon, you're participating in the robbery, and someone is killed because it's inherently dangerous, the law recognizes that you're going to be on the hook for killing, for the murder as well, even though you told Jack not to use the gun and he did it anyway. But there is a new law coming out in California that starts January 1st, 2009, that Governor Brown just signed in September, where now, under the felony murder rule, you will only be charged for the murder if you were the actual person who killed the person, or you aided and abetted in the killing, or you engaged in activity that was in disregard, conscious disregard of the murder that was taking place. Then if that wasn't the situation, and you can show that you were telling the person not to commit the murder, it came as a total surprise, people now are going to have a chance to get out of being charged with first degree murder, even though they were engaged in this particular type of felony. So that is a tremendous change in California law that will take place starting January 1st, 2019, when the standard is that if you're committing a dangerous felony and someone is killed, you are on the hook. I do want to say that that new law, the exception is if a police officer is killed, the person cannot claim that defense. They cannot say, oh, I wasn't the actual person that did it. I didn't aid and abet at all. If there's a police officer killed, everyone is going to be on the hook for that. So the legislature did make that an exception. So let's talk about manslaughter really quickly. Manslaughter is divided into two different types, voluntary and involuntary. Usually you'll see involuntary manslaughter when there's no intent, but as a result of someone's unlawful activity, someone has died. So the common involuntary manslaughter cases you'll see are people who are committing a violation of the law. They're going 100 miles an hour, and as a result of their speeding, they kill someone. So there was no intent to kill, but they engaged in an unlawful activity that caused someone's death. Voluntary manslaughter, you'll usually see people charged with murder. Their whole point is to try and get that murder charge reduced to a manslaughter. And one way to do that is to show that you were acting out of heat of passion. You have to be able to show that you were provoked by something that happened, and that you and another person, a reasonable person, would be provoked by the same thing. So a common example is if you're married, you go home and you find your spouse in bed with someone else. A reasonable person would react out of the heat of passion as well. And then the other thing you have to show in order to be successful for voluntary manslaughter is that there was no time to cool off, that you were acting in that moment while you were still heated during that provocation, and you had no time to act with a cool level head. Third-party provocation is not enough. You can't say, well, her brother said something that made me mad, and so then I killed my wife. It has to be the victim who says something or does something to provoke you. We'll just breeze through this really quick. Imperfect self-defense, you'll see this where a person thinks that someone is going to attack them, but it was unreasonable for them to think that the person was going to attack them, and they will try and claim imperfect self-defense in order to get the murder charge reduced. Involuntary, another way you'll see another example of involuntary manslaughter is A fires a rifle at what he believes is a deer, but hits another hunter. So A says, look, I thought it was a deer. I was hunting. I didn't know it was a person. I didn't intend to kill anyone. He could probably get that reduced to an involuntary manslaughter, that his conduct was simply reckless. So that is it for Chapter 10. Of course, I'm going to download the PowerPoint, and you can look at all of the slides. Remember, we're going to have our guest speaker on next Wednesday, November 7th. You are going to have a quiz on Chapter 10. I will give you notice of that. I think it will be available to you starting no later than Saturday morning, and you'll have until Monday evening to complete it. Okay, I hope you enjoy the rest of your weekend, and I'll see you on November 7th. Bye-bye.